You're listening to the Valley Current.
I want you to picture, just for a second, that you possess the absolute exact blueprints for the world's most advanced artificial intelligence.
Like the ultimate prize right now.
Exactly. You have the actual architectural diagrams, the software code, the hardware configurations, basically everything required to build the frontier tech that is, currently rewiring the entire global economy.
It's a terrifying thought, honestly.
Right. Now, how do you actually protect it? Because you obviously don't publish those blueprints on the internet.
No, definitely not.
And strangely enough, as we're going to find out today, you definitely do not patent them either.
Which sounds completely counterintuitive to most people.
It really does. So your only real option is to just lock them away in the absolute deepest, most secure digital vault your engineers can possibly build.
Right.
But what do you do when the person holding the keys to that vault, the person you actively recruited and paid to build the damn thing, decides to just walk out the front door?
Yeah, it's the exact scenario that keeps, pretty much every general counsel in Silicon Valley awake at night.
Oh, I bet.
And the thing is, it's not a theoretical thought experiment anymore. It is playing out right now in federal court. And it's happening in a way that's genuinely threatening to rewrite the foundational rules of the entire tech industry.
And that right there is the mission for our deep dive today. We're looking at why the entire future of frontier AI rests not on patents and, not on copyrights, but on the incredibly fragile, high-stakes world of trade secrets.
It really is a fragile ecosystem.
It is. We're talking about an invisible legal architecture that holds up multi-billion-dollar empires.
Yeah.
And we are going to explore a very specific, very recent stress test of that exact architecture.
Yeah, and our anchor for this discussion today is a newsletter from the Computer Law Group, or CLG. It's dated May 17th, 2026.
Fairly recent?
Very recent. It's titled Trade Secrets Enter the AI Dock, and it provides just a phenomenal, super granular look at a case that recently went to trial, which is the United States versus Linwei Ding.
So we're going to get deep into the espionage elements of that specific trial. We're going to unpack the surprising reasons tech giants actively avoid patenting their most valuable AI.
Which is fascinating.
It totally is. And we'll explore this really bizarre regulatory landscape where governments are, on one hand, forcing transparency on the outside, while companies are desperately trying to protect their corporate secrets on the inside.
Regulatory squeeze.
Exactly. So whether you're a developer writing code, an entrepreneur trying to build a startup, or just somebody who's insanely curious about who truly owns the AI revolution, you really have to understand the mechanics of this.
Because if one piece of this legal framework falls, the whole ecosystem could essentially just collapse.
It's high stakes. So let's start with the exfiltration itself, because the technical details really matter immensely here.
Right. The setup involves a man named Linwei Ding. He also goes by Leon. And he was a software engineer hired by Google back in 2019. And his specific role at Google is the first really critical piece of context. He wasn't working on the consumer-facing stuff at all.
So he wasn't making the search engine better or anything like that?
No, he wasn't tweaking the search algorithm or designing user interfaces. He was working way down deep in the infrastructure layer.
Okay.
Specifically, he was working on the supercomputing data centers that actually train and serve Google's frontier AI models.
He's working on the machine that builds the machine.
Oh, that's a perfect way to put it, yes.
Yeah.
And to understand the gravity of this whole case, we have to detail exactly what Ding had access to, what federal prosecutors actually referred to as the crown jewels.
The crown jewels. I love when prosecutors use dramatic terms like that.
Me too. So the CLG analysis breaks this down into 7 distinct categories of trade secrets. And this is where we need to get just a little bit technical to understand the immense value of what was allegedly taken.
Okay, lay it out for me, because I think a lot of people just assume AI is, a bunch of really clever code sitting on a laptop somewhere.
Oh, it is far from it. It's so physical. The first category involves the architecture and the functionality of Google's custom tensor processing units. TPUs.
Okay, TPUs. Now, I know standard graphics cards, GPUs, are what companies like NVIDIA make, right? And those are usually the engines for AI. What actually makes a TPU different?
So a standard GPU is incredibly powerful, yeah, but it's fundamentally designed for rendering graphics. It just happens to involve a lot of the same parallel math required for neural networks.
Right.
But a tensor processing unit, a TPU, is an application-specific integrated circuit, an ASIC. Google designed it from the ground up specifically and solely for the heavy lifting of machine learning.
Oh, wow. So it's totally custom.
Exactly. The physical architecture of that chip, how it handles matrix multiplication, that is a massively guarded secret.
Okay, that's category 1.
Right. Then you have the second category, which is their specific customized GPU systems.
Right.
Because even when Google uses standard hardware, like NVIDIA chips, how they rack and stack it is highly proprietary.
Right, because you aren't training a frontier model like ChatGPT or Gemini on just one chip.
Not at all. You're training it on tens of thousands of them simultaneously.
Crazy scale.
Which brings us directly to the third category of secrets Ding had access to, which is the chip-to-chip communication software.
How they talk to each other.
Yes. When you have 10,000 chips trying to train a single neural network, the biggest bottleneck isn't the processing power of the individual chip, it's the latency.
The delay.
Exactly. It's how fast chip number 1 can send petabytes of data to chip number 10,000. If that communication lags by even a fraction of a millisecond across billions of calculations, your entire training run just grinds to a halt.
Wow.
So the software that manages that data flow with practically zero latency is arguably more valuable than the actual physical chips themselves.
It's like having a team of thousands of genius mathematicians, but if they don't have a perfectly synchronized language to speak to each other, they're just a really noisy room.
That's exactly it. And that leads directly to the fourth category, which is the orchestration software.
The orchestration software, okay.
Yeah, this is the overarching management system that binds those thousands of individual chips and servers into one coherent, singular supercomputer.
The brain of the data center, kind of.
Right. And finally, the fifth, sixth, and seventh categories revolve around Google's custom-designed SmartNIC.
SmartNIC?
Yeah, it's a highly specialized network interface card used for these high-speed interconnects. We're talking about the actual blueprints for the physical cards, the drivers that run them, and the firmware embedded on them.
So we aren't just talking about him taking the finished AI model.
No.
We're talking about the entire hardware and software stack required to build an AI factory from absolutely scratch.
Yes. The algorithms are obviously important, but frontier AI is ultimately what we call compute-bound.
Compute-bound.
Meaning your competitive edge isn't just having a really smart algorithm. It's how efficiently you can push unfathomable amounts of data through massive physical clusters of processors. If you have those specific blueprints, you bypass billions of dollars and years of trial and error research and development.
Just skip to the front of the line. Okay, so that's the payload. Now let's talk about the heist itself. Because the timeline spans roughly a year, right? From May 2022 to May 2023.
That's the upload window, yeah.
And Ding didn't just walk into the server room and plug a thumb drive into a mainframe. The mechanics of how he allegedly got this data out are honestly fascinating.
It's basically a textbook example of modern data exfiltration. The central problem for any insider threat, like an employee, is that big tech companies have incredibly sophisticated data loss prevention, or DLP, systems.
Right.
So if you try to download a massive, highly classified source code file directly to an external server, or you try to put it on a USB drive, automated alarms are going to trip immediately.
The security team gets an alert, so how did he bypass it?
According to the indictment, he used a multi-step obfuscation technique.
Okay.
He would open the internal Google source documents, copy the raw text, and then paste that text into the native Apple Notes application on his Google-issued MacBook.
Wait, let me stop you there, because I copy text into Apple Notes literally all the time. It's just a default app. Are you saying the security systems just ignore it because it's a standard, boring program?
Often, yes. Native local applications that are just part of the operating system's baseline functionality are sometimes whitelisted, or they're scrutinized much less aggressively than, say, a direct outward network transfer.
That is wild.
Right. So once the data was sitting locally in Apple Notes, he then converted those notes into standard PDF files. And then he uploaded those generic-looking PDFs from the Google network directly to a personal Google Cloud account.
The conversion to PDF is the really clever part, because he's stripping away all the internal metadata, right?
Yeah.
All the proprietary file extensions that a security scanner would normally be looking for. And he's turning it into the most boring, common document format on Earth.
He essentially laundered the data.
Wow. Laundering data.
Because a PDF upload to a cloud account blends in seamlessly with the background noise of everyday corporate workflow. Everyone uploads PDFs. It completely masked the digital signature of the supercomputing blueprints.
And the sheer volume of what he laundered is staggering. We're talking about over 1,000 unique files uploaded to his personal cloud.
Over 1,000.
During the trial, the coverage estimated it was roughly 255 documents totaling about 14,000 pages of confidential information. That is a systematic, sustained extraction.
It wasn't an impulsive mistake on a Tuesday. It took sustained effort over an entire year. But, the actual act of uploading the files is only half the narrative here.
Right.
The other half, the part that turns this from a standard corporate lawsuit into a federal criminal espionage case, is what Ding was doing when he wasn't at his desk copying PDFs.
The double life. Let's look at the timeline for this, because this is where the plot thickens considerably.
Oh, it really does. So the upload spree begins in May 2022. According to the federal timeline, by June 2022, so just 1 month into this whole process, Ding was already in secret discussions to become the chief technology officer of an early-stage machine learning startup based in Beijing.
Wow.
A company called Rongshu Lianzi Technology.
So he starts downloading the blueprints for an AI supercomputer, and literally 4 weeks later, he's interviewing to be the CTO of a Chinese AI startup.
Yeah. And it gets much deeper. He allegedly traveled to China in late 2022 to participate in investor meetings for this startup.
While still working at Google?
While still at Google. And then, by May 30, 2023, which is right at the tail end of his year-long upload window, he formally incorporated his own machine learning startup in the People's Republic of China.
His own company.
Yes. This was named Shanghai Zishuan Technology, and he named himself the CEO.
Okay, wow. He's still employed by Google at this point, right?
Yes. He doesn't officially resign from Google until December 2023.
That is bold.
And in the middle of all this, by November 2023, his new startup was formally admitted to a PRC business incubator program called Miracle Plus. And there he allegedly pitched his company to investors, explicitly touting his experience with Google's supercomputing platforms.
Okay, I have to play the skeptic here for a minute.
Go for it.
Because on the surface, it looks incredibly damning. You're downloading supercomputer blueprints while starting a rival company in a foreign country. But in an actual court of law, how exactly does a prosecutor prove his actual intent behind the keyboard?
That is the million-dollar question.
Right. I mean, I've downloaded work files to my personal cloud before just so I could, work from my home laptop on a weekend. If I happen to also be looking for a new job at the same time, am I committing espionage? Couldn't a defense lawyer argue he was just an ambitious guy who occasionally worked from home?
That tension you just described is the central pivot point of the entire case. It's what elevates this from a simple breach of an employment contract to a federal criminal trial.
Okay.
The government doesn't just have to prove that the files move from server A to server B. They actually have to prove his state of mind. They have to prove why he moved them.
Right.
Because under the law, there's a massive difference between moving files to benefit yourself commercially and moving files with the intent to benefit a foreign government.
Because the penalties are completely different, I assume?
Astronomical difference. Let's look at how the timeline of the trial actually played out. So Ding resigns in December 2023. A few months later, in March 2024, the FBI arrests him in Newark, California.
They move fast.
Very fast. They seize his devices, they find the cloud backups. The case goes to trial in January 2026. It's an 11-day trial in federal court, and the jury deliberates for a grand total of 3 hours before convicting him on all 14 counts.
3 hours.
3 hours.
3 hours of deliberation after almost 2 weeks of highly technical testimony. That tells me the jury didn't buy the working from home defense for a single second.
No. They found the prosecution's timeline overwhelming, and the stakes of that conviction are severe. For the commercial theft counts, which allege he stole the files for his own economic benefit, he was facing up to 10 years in prison and a $250,000 fine per count.
Per count?
Per count. But for the economic espionage counts, which allege he intended to benefit a foreign instrumentality, in this case, Chinese entities, the maximum jumps to 15 years and a $5 million fine per count.
Wow. I know federal judges rarely hand down the maximum statutory sentences, but given the sheer financial value of what he took, the sentencing guidelines are going to be brutal, right? I mean, Google spent billions developing those TPUs.
Exactly. The federal sentencing guidelines heavily factor in the intended loss or the reproduction costs avoided by the thief. If you steal a $100 software program, you get a slap on the wrist. If you steal the foundational architecture of a trillion-dollar industry, the guidelines push you toward a very, very lengthy prison term.
So you have a swift jury verdict, a seemingly rock-solid timeline of events, and a guy looking at serious time. It feels like a closed book.
It does.
But this brings us to the massive twist in the story. Despite the jury coming back in 3 hours, this entire conviction might actually unravel.
Yeah, this is where we get into the deep legal doctrine, and it is absolutely fascinating. A few months after the conviction, on May 12, 2026, there was a post-trial hearing before U.S. District Judge Vince Chhabria.
Right.
And Judge Chhabria threw a massive curveball at the prosecution.
He essentially looked at the federal prosecutors and said, I'm not sure your legal theory holds up and I might throw out some of these convictions, which is a wild thing for a judge to do after a jury has already spoken unanimously.
It is rare, but a judge definitely has the authority to issue a judgment of acquittal if they believe the evidence, even when viewed in the light most favorable to the prosecution, simply doesn't meet the statutory definition of the crime.
Okay, so what did he see that the jury didn't?
Judge Chhabria highlighted two very specific doctrinal concerns that attack the absolute core of how we legally define digital theft. Let's break down the first one. It revolves around the definition of the actual word theft under the federal commercial theft statute.
Okay, walk me through the logic on that.
Remember the timeline. The actual exfiltration of the files, the copying to Apple Notes and uploading to the personal Google Cloud happened between May 2022 and May 2023.
Right, the big upload window.
But the specific theft charges that the government brought were largely based on an event that happened later, in December 2023. Less than 2 weeks before Ding officially resigned from Google, he went into his personal cloud account and downloaded those already uploaded PDF materials directly onto his personal laptop.
Wait, let me make sure I'm getting this completely straight. He didn't take new files from Google in December.
No.
He just took the files he had already stolen a year earlier, which were just sitting in his own personal cloud, and he dragged them onto his local hard drive.
Precisely. And Judge Chhabria looked at that December action and asked a very fundamental, almost philosophical legal question.
Yeah.
He asked, if a defendant has already stolen trade secrets and secured them in a cloud account, does the act of moving those exact same secrets from the cloud to a laptop constitute a new separate act of theft?
Okay, it's like, let's say if I break into a museum and steal a priceless painting and I hide it in my basement.
Right.
And then a year later, I decide the basement is too damp, so I carry the painting upstairs and put it in my attic. Did I just commit a brand new crime of theft by carrying it up the stairs? Like, can the police charge me with the second count of robbery for that?
That is exactly the analogy to hold in your head. During the hearing, Judge Chhabria's phrasing on the record was remarkably similar. He basically said, I don't understand how moving the stuff he already stole to a different medium can be considered theft of trade secrets. He pointed out that Ding had already appropriated the files a year prior. The theft was complete back in 2022.
That makes a lot of sense physically. But in the digital world, moving something usually means copying it, right? So how did the prosecutors respond to the judge's skepticism?
The assistant U.S. attorneys, Casey Boom and Roland Chang, pushed back hard. They argued that the December downloads were two separate instances of the same crime.
Interesting.
Their argument hinges on the exact text of the statute. The commercial theft law covers the knowing theft, appropriation, conversion, duplication, or receipt of a trade secret.
Duplication.
Right. From the government's perspective, in the digital realm, every single time you duplicate or transmit the file to a new device, you are exerting unauthorized control anew. You are committing a fresh duplication or conversion.
I see their point. In the physical world, there's only one painting. But in the digital world, when he moves it to his laptop, there's now a copy in the cloud and a copy on the laptop. He literally duplicated the stolen good.
It forces us to ask where a digital crime actually begins and ends. If I steal a file and an automated backup system on my computer syncs it to 3 different servers over the next week, did I commit 4 felonies or 1?
Why?
If the court rules that the initial appropriation is the only defining act, it dramatically narrows the window prosecutors have to charge these crimes.
That's a massive doctrinal headache. But you mentioned a second concern from the judge, which might be even more damaging to the prosecution.
Yes. The second dilemma has to do with the more severe charges, which are the economic espionage counts.
Right. And you referred to this earlier as the time travel of intent. Unpack that for me. What does that mean?
So to convict someone of commercial theft, you just have to prove they stole it to make money for themselves. That's relatively easy. But to convict someone of economic espionage under the law, the government must prove beyond a reasonable doubt that the defendant intended or knew that the offense would benefit a foreign government, a foreign instrumentality, or a foreign agent.
And the prosecution argued that Ding's startup in China and his meetings with that PRC business incubator, Miracle Plus, proved he was trying to benefit a foreign entity.
They did. But Judge Chhabria zeroed in on the timeline again. The actual upload window, the physical act of taking the files, happened between May 2022 and May 2023. But Ding's major documented contacts with the Chinese incubator program happened in November 2023.
6 months after he stopped downloading the file.
Right. The judge openly questioned whether you can use his actions in November 2023 to retroactively prove what was going through his head a year earlier. The judge characterized using those later contacts to establish his state of mind during the upload period as inferentially too great a leap.
Okay, let's play that out practically. Let's say Ding is just a deeply arrogant, disgruntled employee. He thinks he's smarter than Google, so he steals the files in 2022 strictly to build his own personal startup in his garage. At that exact moment, his only intent is selfish commercial theft.
Okay. Yeah.
Then, 6 months later, he realizes building an AI supercomputer is really expensive and he needs funding. So he goes looking for venture capital, and the only people who will talk to him happen to be tied to a foreign state incubator.
Right.
If that's the true story, he never actually had espionage intent at the time he took the files. He just developed it later out of desperation.
That is exactly the distinction the law makes. To hit him with espionage, the specific intent to benefit a foreign government must be present at the exact moment of the misappropriation. You cannot use a time machine to prove intent.
Wow.
If the intent changes later, the initial crime doesn't magically upgrade from commercial theft to espionage.
Which means the burden of proof for the government is astronomically high. You basically have to have a text message from the guy on the literal day of the theft saying, I am downloading this right now for a foreign government.
It is notoriously difficult to prove. And the CLG newsletter provides some vital historical context to show just how strictly the courts enforce this burden of proof. Ding is far from the first person to face these dual charges.
Let's talk about the track record, because there are some really wild cases in the history here.
The most illustrative example is the 2012 case of the United States versus Han Wan-jin. This case really produced the signature warning for federal prosecutors regarding the Economic Espionage Act.
Okay, what happened?
Jin was a software engineer accused of stealing massive amounts of trade secrets from Motorola. The circumstances of her arrest were incredibly dramatic. She was stopped by customs agents at O'Hare International Airport in Chicago as she was literally about to board a one-way flight to China.
Okay, so caught red-handed fleeing.
Exactly. When they searched her, they found thousands of confidential Motorola documents. They found over $30,000 in undeclared cash. And, most crucially, they found classified Chinese military documents detailing telecommunications projects for the Chinese military.
I mean, come on. You have the stolen corporate secrets in one hand, you have literal foreign military documents in the other hand, you have a bag full of cash, and you're fleeing the country. That sounds like a movie script. That has to be a slam dunk espionage conviction.
You would certainly assume so, right. But she opted for a bench trial, meaning a judge decided the verdict instead of a jury. And the judge convicted her of commercial theft, but acquitted her of all the economic espionage charges.
How is that even possible?
The court found that despite the overwhelming circumstantial evidence, the military documents, the cash derogation, the government simply hadn't produced enough direct evidence to prove beyond a reasonable doubt that she intended to benefit the Chinese government with those specific Motorola files at the time she took them.
You're kidding.
No. The judge essentially said, I know she stole them for herself, but I can't definitively prove she was acting as an agent of the state at that moment. She ended up getting a 4-year sentence for the commercial theft, totally avoiding the massive espionage penalties.
That is a staggering legal threshold. If you can't prove espionage with military documents in the defendant's suitcase, how do you prove it against a guy who just went to a startup incubator pitch meeting 6 months after the fact?
That's the exact problem Judge Chhabria is wrestling with. There's another key precedent mentioned in the source, which is the United States versus Walter Liu from 2014.
Okay.
This was historically significant because it was the first time a federal jury ever convicted someone under the economic espionage statute. Liu was found guilty of stealing DuPont's trade secrets regarding titanium dioxide manufacturing and selling them to a Chinese state-owned enterprise. The trial judge sentenced him to 15 years.
So they finally got one to stick.
They did. But even then, it wasn't smooth. The Ninth Circuit Court of Appeals, which is the same appellate court that governs California in the Ding case, scrutinized the Liu conviction heavily. They ended up partially reversing it and remanding the case back to the lower court. Liu was eventually resentenced to 12 years.
The source also lists a bunch of other high-profile tech theft cases, right?
Yes, it outlines a whole spectrum of outcomes. You have Xiaorong Yu, who got 14 years for stealing BPA-free CAN coding technology. You have Anthony Lewandowski, the infamous case where he stole self-driving car files from Google's Waymo.
Right, that was huge in the news.
He only got 18 months and eventually received a presidential pardon. Xiaolong Zhang took Apple car secrets and got a mere 120 days. And then at the extreme other end, you have Yanjun Xu. He was an actual credentialed Chinese intelligence officer who was extradited to the U.S. and sentenced to 20 years.
So looking at that list, the pattern becomes really obvious. Convicting someone of espionage under the federal statute is almost impossible unless the defendant is literally a card-carrying intelligence officer for a foreign state.
Exactly. The Hanwan Jin split verdict pattern, convicted of theft, acquitted of espionage, is the exact dynamic Judge Chhabria is testing with Linwei Ding. And the Walter Liu remand shows that the Ninth Circuit watches these specific espionage sentences like a hawk. Trial judges know that if they let a shaky espionage conviction stand, the appellate court will likely tear it apart.
So bringing this back to the Ding case, what are the actual odds that Judge Chhabria throws out the jury's verdict on the heavy charges?
The CLG newsletter actually provides a calibrated probability for this. Based on their analysis of the judge's statements in the case law, they estimate there's a 35 to 35% chance that Judge Chhabria vacates one or more of the espionage counts at the upcoming June 16, 2026 hearing.
That is a massive level of uncertainty for what is essentially the Department of Justice's flagship AI prosecution right now.
Massive.
Okay, let's zoom out here for a second, because this raises a massive structural question. If proving theft is this difficult and proving espionage is practically impossible, why is Google relying on this flimsy legal framework in the first place? Google has infinite resources. They spent billions developing the TPU architecture and the orchestration software. Why not just patent the whole thing? If you hold the patent, you own it. It doesn't matter if someone steals the files, they can't legally build it anyway.
That is the perfect question to pivot us into the second major theme of our deep dive today, which is the strategic architecture of intellectual property.
Let's do it.
The decisions these massive tech companies make about how to protect their AI aren't just, administrative legal formalities. They are existential business strategies. To understand why trade secret law is the ultimate bloody battleground for AI, we have to methodically contrast the four main regimes of intellectual property.
Okay.
Trademarks, copyrights, patents, and trade secrets.
Let's lay out the map for our listeners. We'll start with the easiest one to conceptualize, which is trademarks.
Trademarks are straightforward. They protect words, symbols, logos, or devices that identify the source of goods or services.
Right.
It's the Google logo. It's the name ChatGPT. It's the little apple with a bite taken out of it. The entire purpose of trademark law is to prevent consumer confusion in the marketplace.
Right. It protects the brand, but it offers absolutely zero protection for the underlying technology.
Yeah.
Like, if I manage to build a completely identical, highly advanced search engine, I am legally allowed to launch it. I just can't call it Google or use their multicolored logo.
Yeah.
So trademarks are out for protecting the tech.
Exactly.
Next up is copyrights. Now, this seems like the obvious path for software. The newsletter calls it the easy but ultimately weak path. Why is that?
Well, it is incredibly easy to get a copyright.
Right.
In the United States, copyright protection is automatic the moment a work is fixed in a tangible medium of expression.
Right.
If you open a text editor right now and write 10 lines of Python code, you instantly own the copyright to that code.
Yeah.
You don't even have to register it to hold the right to it. It protects you against unauthorized reproduction, the creation of derivative works, and public distribution.
That sounds great. If I spend 5 years writing the millions of lines of code that make up a frontier AI model, I own the copyright to that text. If Leon Ding copies my code, he's violating my copyright. So why isn't that enough to protect the company?
Because copyright law has a massive fatal blind spot when it comes to frontier technology, and it's explicitly codified in Section 102B of the Copyright Act.
Section 102B.
Copyright only protects the expression of an idea, not the idea itself. The exact text of the statute explicitly says that copyright protection does not extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery.
So it protects the words, but not the actual function.
Precisely. Let's use a non-tech analogy. Imagine you invent a revolutionary new method for baking a cake that requires baking it at 3 different temperatures in a very specific sequence.
Okay, I'm with you.
And you write a book detailing the recipe. Copyright protects the specific words you use to write the book. Nobody can photocopy your book and sell it. But copyright absolutely does not stop anyone from reading the book, understanding your new 3-temperature baking procedure, and baking the cake themselves. They can even write their own book, describing the same procedure using different words.
Oh, wow. Okay, so how does that apply directly to an AI model?
Your specific lines of C++ or Python code are protected. If someone literally copy-pastes your code file, that's copyright infringement. But the underlying mathematical algorithm, the genius procedure for how the model trains itself, the method of reinforcing the data, none of that is protected by copyright.
That's a huge hole.
It is. The Supreme Court reaffirmed this hard line between idea and expression in the famous Google v. Oracle case. If a competitor can figure out your underlying training method and they write their own original code from scratch to execute that exact same method, copyright cannot stop them. Under copyright law, independent creation is a complete 100% valid defense.
That makes total sense. Copyright is basically useless for protecting the actual mechanics of a new invention. Which leads us to the heavy artillery, the regime that is literally designed to protect inventions, which is patents.
Patents, yes.
Now, this is the one I would assume tech giants love. A patent gives you a 20-year absolute monopoly. Nobody can make, use, sell, or import your claimed invention for 2 decades, even if they independently invented themselves in a vacuum without ever meeting you. It is strict liability.
True monopoly.
Right. So if I have a brilliant AI that is going to revolutionize the world, why on earth wouldn't I just patent it and lock out the competition entirely?
Because of what we call the patent bargain.
The bargain.
The government doesn't just hand you a 20-year monopoly for free. You have to give the public something immensely valuable in return. Under the federal patent statute, specifically 35 U.S.C. Section 112, you must provide a full enabling public disclosure of your invention.
Right, you have to explain it.
Yes. You have to write a detailed document explaining exactly how your invention works, and you have to publish those exact blueprints to the world so that anyone skilled in the field could replicate it.
You literally have to show your hand. You have to publish the recipe for the secret sauce on the internet.
Yes. And for the AI industry, that is an incredibly dangerous bargain for 2 main reasons. The first reason is just speed. The patent process can take years, and a 20-year monopoly sounds great for a pharmaceutical drug. But in frontier AI, the technology cycle moves in months, not decades. By the time your patent is actually approved, the architecture might be totally obsolete.
That's a really good point.
But the second reason is the really fatal flaw. Many of the most valuable AI innovations are simply ineligible for patent protection in the first place.
Hold on, why is that? If I invent a totally new, revolutionary neural network architecture, it's an invention, it's a machine doing work. Why wouldn't it be patentable?
This is where we run into the Supreme Court framework established in a landmark case called Alice Corp v. CLS Bank International.
The Alice case.
Historically, you can patent physical machines, processes, and compositions of matter. You cannot patent laws of nature, natural phenomena, or abstract ideas. You can't patent gravity, and you can't patent a math equation like the Pythagorean theorem.
Obviously.
Right. So in the Alice case, the Supreme Court ruled that abstract ideas and mathematical concepts do not magically become patentable simply because you execute them on a generic computer.
Oh, I see exactly where this is going.
Right. When you strip away the hype, what is a frontier AI model? It is, at its absolute core, an incredibly complex series of mathematical matrix multiplications and statistical probability algorithms. When tech companies try to patent their advanced machine learning algorithms, the U.S. Patent and Trademark Office often rejects them, arguing they fail the Alice test because they are just mathematical concepts executed on conventional hardware. They view it as trying to patent math.
That is the ultimate trap. Think about what you just said. To get a patent, you have to file a detailed application disclosing your secret blueprints to the public. But because it's AI, the patent office might review your application, declare it's just math, and reject the patent. So now you don't get the 20-year monopoly, and you just published your secret recipe in a public government database for every competitor on Earth to read and use totally legally.
Exactly.
It's Russian roulette for your intellectual property.
It is a devastating gamble. You expose your most valuable secrets and get absolutely no protection in return. And that reality, the weakness of copyright and the extreme danger of patents, leaves us with the fourth and final IP regime. The perpetual gamble, trade secrets.
The granddaddy of them all. This is the realm of the Economic Espionage Act, which Ding was charged under, and the Defend Trade Secrets Act, which gives companies the right to sue civilly.
A trade secret is incredibly broad. It can be almost anything. A formula, a method, an AI model's training weights, a curated data set, even a customer list. As long as it derives actual economic value from not being generally known, and the owner takes reasonable measures to keep it a secret, it is protected by law.
And this is the real superpower of trade secrets, right? Unlike a patent that expires after 20 years, a trade secret can theoretically last forever.
Forever?
The classic example the source material mentions is the Coca-Cola formula. It has been a heavily guarded trade secret since 1886. Think about that for a second. If John Pemberton had patented the Coca-Cola recipe back in 1886, that patent would have expired in 1906.
Hello.
For the last century, anyone on Earth would have been able to manufacture and sell generic Coca-Cola legally. But because they chose the trade secret route and kept the recipe locked in a vault, they still own the exclusive rights to it today, over 130 years later.
It's amazing.
Furthermore, trade secret law has massive extraterritorial reach. If a U.S. entity owns the secret, the federal government can go after conduct that happens abroad, which is exactly why Ding's actions in China are relevant.
But, every superpower has its kryptonite. And the fatal flaw of a trade secret is its complete, absolute vulnerability to reverse engineering, independent creation, or accidental disclosure.
Right.
If a competitor legally buys your product, takes it apart in a lab, and figures out how it works, your trade secret is gone forever. You have zero legal recourse. You can't sue them. They're completely allowed to use what they found.
You just lose it instantly.
Yes. The Supreme Court has cemented this principle in two major landmark cases mentioned in the text, which are Kiwani Oil Code v. Bike Run Corp. And Benito Boats v. Thundercraft Boats.
Okay.
The courts ruled that state trade secret laws do not conflict with federal patent laws, precisely because reverse engineering remains a constitutionally protected right. It is the delicate balance of the entire IP ecosystem.
Makes sense.
The court's logic is basically this. If you invent something and you want absolute protection against someone reverse engineering it, you have to strike the bargain. You have to get a patent and disclose your invention to the public. If you refuse to do that and you decide to keep it secret, you accept the inherent risk that someone else might figure it out independently or just take your product apart.
Okay, let's bring this theoretical legal framework into the real world of the AI era. Why is trade secret law the undisputed champion, like the god regime for frontier AI models like ChatGPT, Gemini, or Claude?
It becomes super clear when we take the components of a frontier AI system and map them directly to the IP regimes we just discussed. Let's start with the foundational physical hardware. The physical accelerators, the actual silicon TPU chips, the networking cables.
Right.
Those might get patented. Why? Because the disclosure cost is justified. You cannot easily hide the physical structure of a chip once you sell the server to a customer. Someone's going to open the box and look at it. So patent prevents them from just cloning the hardware layout.
So the physical silicon gets patented. Check.
Right. Next, you have the basic code expression. The millions of lines of standard programming that make the software run, the user interface code, that gets copyrighted automatically.
A basic code gets copyrighted. Check.
But then you have the actual magic. The neural network architectures, the billions of parameters and model weights, the heavily curated data pipelines used to feed the model, the specific protocols for reinforcement learning from human feedback, or RLHF.
Which is what teaches the AI not to output toxic garbage.
Exactly. These are the true differentiators between a trillion-dollar company and a failed startup. These cannot be patented because of the Alice doctrine. Like we said, they're too close to abstract math. And they are excluded from copyright under Section 102B because they are methods and procedures, not just expressions. Therefore, by process of elimination, they must be kept as trade secrets. It is literally the only regime left.
They are the dark matter of the AI universe. They are completely invisible to the outside world. They are incredibly massive in their financial value, and their gravity is the only thing holding the entire industry together.
That's a great analogy.
But as we established, trade secrets are incredibly fragile. And the source material shares a dramatic, honestly terrifying cautionary tale about just how fragile they are in practice. Let's talk about the Anthropic leak.
Oh, this is a perfect illustration of the stakes. This happened just recently, on March 31st, 2026.
Yeah.
Anthropic is one of the leading frontier AI labs in the world. They're the creators of the Claude models.
Right. Huge player.
They were performing a routine update to an NPM package. Now, for those who aren't software engineers, NPM is essentially a package manager. It's a massive registry where developers share and update libraries of code.
Like an app store for developer tools, basically.
Exactly. Anthropic was updating a specific package called Claude Code to version 2.1.88. But during the update, a developer made an error and accidentally published the internal source maps alongside the public code.
Okay, I'm going to need you to translate that into English for me. What is a source map, and why is it so bad to publish it?
Sure. When companies ship software, they usually minify or obfuscate the code. They run it through a program that strips out all the human-readable names, all the helpful notes the developers left for each other, and shrinks it down into a dense, unreadable block of machine text.
Okay.
It works perfectly for the computer, but a human competitor looking at it would just see absolute gibberish. A source map is the decoder ring. It is a file that maps that machine gibberish back to the original, beautifully structured, human-readable code. If you accidentally publish the source map, you are handing the world the raw, translated blueprints of your software.
Wow. And this wasn't just a minor glitch exposing a few lines of code, right?
It was catastrophic.
Yeah.
In an instant, because of that one package update, approximately 512,000 lines of unobfuscated, crystal-clear TypeScript code were exposed across roughly 1,900 internal files.
500,000 lines.
Yes. And it included incredibly sensitive architectural secrets. It exposed their full agent harness, which is the underlying framework that allows the AI to interact with external tools and make decisions. It exposed the core system prompts that dictate the AI's fundamental behavior and safety rails. Ouch. It exposed the design of their retrieval augmented generation engine, which is how the AI fetches external information. And it even exposed 44 hidden feature flags for projects they hadn't even announced yet.
It's like having a vampire as your ultimate bodyguard. The vampire is incredibly powerful. It can live forever, far longer than a 20-year patent. Its power crosses international borders. But one tiny crack in the window blinds, one little accidental ray of sunlight hitting it, and the whole thing turns to dust instantly. One packaging error by a tired developer on a Tuesday afternoon, and 500,000 lines of secret architecture are just gone.
That's exactly it. And pay close attention to how Anthropic was forced to react legally to this. When they realized the leak happened, they didn't run to a judge and file a trade secret lawsuit to pull the code down. They couldn't. Instead, they had to issue a wave of DMCA copyright takedown notices to platforms like GitHub, where the code was being mirrored.
Wait, hold on. Why did they use copyright law if we just spent 20 minutes establishing that the magic of AI is a trade secret?
Because the very moment those source maps were accidentally published to the open internet and mirrored on countless servers, the legal status of trade secret instantly evaporated.
Oh, because it wasn't a secret anymore.
Right. The law is crystal clear. A trade secret only exists as long as it remains a secret. Once it is broadly disclosed, even accidentally by the owner, the protection is permanently destroyed. They could not claim trade secret protection anymore. However, because the literal text of the code is automatically copyrighted, they were able to use the swift administrative DMCA process to force websites to delete the copy text.
But that's closing the barn door after the horse has learned to fly. You can force a website to take down the text file using copyright, but the damage to the underlying method is already done. Competitors saw the system prompts, they read the agent harness architecture. You can delete the file from a server, but you cannot erase the architectural knowledge from the minds of the rival engineers who read it. Copyright protects the exact text, but as we said earlier, independent creation of the idea is perfectly legal.
It is. As the CLG newsletter notes, this asymmetric vulnerability, where billions of dollars of IP can be destroyed by a single packaging error, is not a bug in the trade secret regime. It is a structural feature of the law.
And this incredible inherent fragility is currently running headfirst into a global regulatory landscape that is demanding the exact opposite of secrecy. Governments are demanding absolute transparency. This is what we call the regulatory squeeze.
The squeeze, yes.
Let's explore that, because it feels like an unsolvable contradiction. How does a government regulate an AI model if its inner workings are legally hidden behind impenetrable trade secret walls? We are seeing a striking convergence in how massive governing bodies are trying to thread this needle.
The source material analyzes two massive pieces of recent legislation here. California's Transparency and Frontier Artificial Intelligence Act, widely known as SB 53, and the European Union's Sweeping AI Act.
Let's look at California first.
So SB 53 took effect on January 1st, 2026. It specifically targets what it calls large frontier developers. These are defined as companies with over $500 million in affiliate revenue that are training massive, computationally intensive models.
So it's aiming directly at the heavy hitters: Google, OpenAI, Anthropic, Meta.
Exactly. And the law mandates that these developers must publish a detailed frontier AI framework. They must provide sweeping transparency reports about their model's capabilities and safety tests. And crucially, they must submit 15-day critical incident reports to the California Office of Emergency Services if something goes wrong.
Right.
The EU AI Act, specifically under Article 78, imposes very similar parallel transparency obligations on providers of high-risk AI systems across Europe.
Okay, stop right there. Because the government is saying, we want to know everything. We want to see the safety data, we want to see the training pipelines, we want to see the incident logs to make sure this thing isn't going to accidentally launch a missile or crash the stock market.
Reasonable demands.
Right, but wait. We just established that forcing a company to disclose these specific procedures to the public would instantly destroy their trade secrets. Does the government just casually invalidate billions of dollars in intellectual property in the name of safety?
This is the grand paradox of current AI regulation. And the lawmakers are well aware of it. Both pieces of legislation explicitly carve out legal protections for those exact trade secrets.
Really? How does that work?
Under California's SB 53, companies are legally allowed to heavily redact trade secrets, proprietary cybersecurity protections, and national security matters from their public disclosures. The catch is, they have to keep the unredacted records securely on file for 5 years in case regulators demand an audit.
And what about the EU? Europe is usually much stricter about corporate compliance than the US.
Even the EU respects the boundary. Article 78, paragraph 1A of the EU AI Act mandates that national authorities and regulators must respect confidential business information or trade secrets, including source code. It states that regulatory authorities can only request what is strictly necessary to assess compliance, and they must securely delete the data as soon as they are done with the assessment.
What's truly fascinating here is that the law is contorting itself to have it both ways. Legislators are demanding public governance, safety oversight, and external transparency to satisfy a nervous public.
Right.
But simultaneously, they're completely validating and fortifying the corporate trade secret wall internally. They are essentially telling these tech giants, tell us absolutely everything about how dangerous your machine is, but make sure you keep the actual mechanics a total secret from the public.
It creates an immense underlying tension in the system. Imagine a scenario where a frontier AI model hallucinates or fails in a way that causes real-world harm, like, say, a massive autonomous driving failure or a localized grid disruption.
People would freak out.
They would. The public, the press, and independent researchers will immediately demand to see the model weights, the raw training data, and the specific RLHF protocols that led to the failure. They'll demand open source transparency, and the tech company will simply point to the text of SB 53 or the EU AI Act and say, we are legally protected from showing you that. That is a protected trade secret.
It is a total collision course between public safety and private intellectual property.
Exactly.
But there is a second layer to this regulatory squeeze, and it brings us right back to the very beginning of our deep dive today, the California factor.
Oh, this is so important.
Because we've established that trade secrets are the only thing protecting these models, and a trade secret relies entirely on a company taking reasonable measures to keep it secret. But the biggest vulnerability isn't a hacker breaking into a server. The biggest vulnerability is the human beings who build the model.
The employees.
Right. If these secrets are so unfathomably valuable, how do these companies keep their employees, the brilliant engineers who spent 3 years designing the architecture, from just quitting, walking across the street to a well-funded competitor, and recreating the entire system from memory?
In almost any other industry, in almost any other state in America, companies use standard contractual restraints. Primarily, they use non-compete agreements.
Cannabis stuff.
Yeah. When you get hired, you sign a contract legally agreeing that if you leave the company, you will not work for a direct competitor for a period of 1 to 2 years. It enforces a cooling off period so your knowledge becomes stale.
Right.
Alternatively, in some states, companies rely on a legal concept called the inevitable disclosure doctrine. This is where a Jody will actively block an employee from taking a specific new job, even without a non-compete. because the court decides it's simply inevitable that the employee would accidentally spill their former employer's secrets in the new role.
But the frontier AI industry isn't based in most states. It is overwhelmingly concentrated in one very specific legal jurisdiction, which is California. And California employment law is a completely unique pressure cooker.
It is the defining geographic reality of the tech industry. Under California Business and Professions Code Section 16600, non-compete agreements are absolutely void as a matter of public policy.
Void.
Completely void. It does not matter how narrowly drawn they are, how much you pay the executive to sign it, or how specialized the role is. You cannot enforce a non-compete against an employee in California. The state legislature even passed recent amendments extending this prohibition to cover contracts that were signed outside of California if the employee comes to work in the state.
That's aggressive. And what about the inevitable disclosure doctrine? If a judge can't enforce a contract, can they still stop an employee from jumping ship to a rival?
California courts explicitly despise the inevitable disclosure doctrine. In a landmark 2002 case called White v. Schlag Dole Company, the California court firmly rejected the doctrine. The judge's logic was that allowing inevitable disclosure to block a job change is basically just allowing a company to create an after-the-fact covenant not to compete, which violates the core public policy of employee mobility.
So practically speaking, a senior infrastructure engineer at Google can quit their job on Friday afternoon, walk into the lobby of OpenAI or Anthropic on Monday morning, and immediately start writing code.
Yes.
And Google cannot use an employment contract or a judge's injunction to stop them from taking the job.
Exactly. Employee mobility in Silicon Valley is practically absolute.
Yeah.
And this structural reality is the absolute crux of our entire deep dive today.
It really is.
Because tech companies operating in California are legally stripped of the ability to use non-competes to stop their engineers from leaving.
Yeah.
Trade secret law becomes the sole pillar holding the roof up. Specifically, the threat of ruinous civil lawsuits under the California Uniform Trade Secrets Act and the terrifying threat of federal criminal prosecution under the Economic Espionage Act is the only load-bearing legal structure keeping Silicon Valley's intellectual property from bleeding out into the street.
It is the only dam holding back the flood. Which brings us completely full circle back to Linwei Ding and Judge Vince Chhabria. This isn't just a story about one arrogant engineer who uploaded some PDFs to his cloud drive. This trial is a profound stress test of the fundamental foundation of the tech industry.
It is. The contractual restraints that act as a safety net in other states simply do not exist for these AI giants. So the entire weight of a trillion-dollar industry rests purely on how a federal judge defines a trade secret violation.
Right.
When Judge Chhabria openly questions whether moving an already stolen file from a cloud drive to a local laptop constitutes a new theft, he isn't just pondering philosophy. He's poking at the very margins of this load-bearing wall.
Let's play out the consequences of that. If the courts ultimately decide that digital trade secret theft has to be defined as this incredibly narrow, immediate event, meaning that continuing to manipulate, copy, or download the data months later isn't covered by the statute, it drastically shrinks the timeline prosecutors have to bring charges.
It does.
It makes it vastly harder for companies to police the actions of their ex-employees. And if prosecutors can't secure espionage convictions because a 6-month gap between stealing files and meeting foreign investors is considered too great a leap to prove intent, then the terrifying deterrent effect of the Espionage Act starts to crumble.
And if that deterrent crumbles, the architecture of the industry shifts. You have multi-billion-dollar empires resting entirely on the fragile legal concept of reasonable measures.
Reasonable measures.
Yeah. When Ding's lawyers, or any defense lawyers in these cases, go to trial, their primary strategy is often to attack those measures. They argue that the company's access controls were sloppy. They argue the exit interviews were poorly conducted. They argue that if an employee could simply paste code into Apple Notes, then the company wasn't actually taking reasonable measures to protect the data, and therefore, under the law, the data was never legally a trade secret in the first place.
It's an incredible, precarious ecosystem. We started this hour by looking at a single Google engineer's upload spree, but what we've actually uncovered is a hidden world where the future of global AI dominance isn't just decided by who writes the cleverest code or builds the biggest data center.
Not at all.
It's decided by the invisible high-stakes architecture of intellectual property law. We've mapped out a landscape where copyright is too weak to protect the methods, where patents are a suicidal gamble that forces you to publish your secrets, and where trade secrets act like an immortal vampire that can be instantly turned to dust by a single ray of sunlight from a developer's careless typo.
The Coca-Cola formula survives because nobody's allowed to look inside the vault in Atlanta. But frontier AI isn't a static vat of soda syrup. It is a continuously evolving, highly mobile digital asset being built by brilliant human engineers who possess an absolute, legally protected right to walk out the door at any time. The tension between those two realities is what makes this area of law so explosive.
Which leads me to a final lingering thought for you to chew on as we wrap up today.
Oh, I like these.
Throughout this deep dive, we've talked about what constitutes theft. But the boundaries of what is fair play are constantly shifting. In the CLG newsletter, there's a reference to a famous 1970 legal case involving the chemical company DuPont.
Oh, the aerial photography case.
Yes, DuPont was building a massive, highly proprietary chemical plant. While it was under construction, a competitor hired a pilot to fly a small airplane over the construction site and take detailed aerial photographs of the layout, trying to deduce their manufacturing secrets.
Neat.
Yeah. Very. So DuPont sued. And the competitor argued, hey, we didn't trespass, we didn't break any locks, we just flew a plane in public airspace and looked down. That's just creative reverse engineering.
Right, they thought they found a loophole.
But the court ruled against the competitor. The judge declared that taking aerial photos was an improper means of discovering a trade secret. The court essentially reasoned that a company shouldn't be forced to build a massive physical roof over an active construction site just to protect its IP from corporate spies and airplanes.
It's a classic case because it proves the law recognizes that there are competitive practices that cross an invisible line of fairness, even if they don't involve literal trespassing, hacking, or contract breaches.
Exactly. So fast forward to today, right now. We know that AI models are treated as uncopyrightable, unpatentable trade secrets. Imagine a world where a scrappy startup unleashes their own AI model and directs it to systematically query, prompt, and mathematically analyze the outputs of a massive rival AI like ChatGPT, millions of times a second. The startup's AI analyzes those responses, maps the probabilities, and effectively reverse engineers the hidden, secret training methods of the trillion-dollar giant. No hacking involved, just asking questions really, really fast.
Oh.
Is that just the constitutionally protected right of independent reverse engineering? Or, in the age of neural networks, is unleashing an AI to interrogate another AI the modern digital equivalent of flying a spy plane over the chemical factory?
That is wild.
Think about that the next time you ask a chatbot how it actually works.
It is the exact question that will define the next decade of technology law.
Thank you for joining us on this deep dive into the invisible legal forces shaping our future. Keep questioning the architecture around you, and we'll see you next time.
Tune in next time on The Valley Current.